You have not entered any numbers. Please re-enter the meeting password followed by pound. You are in the meeting now. There are 3 participants in the meeting. You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting. You are now in a breakout session.
Hello. Hello.
Hello.
Yes, hello. Yes.
Good morning.
Yes, good morning.
Okay. Sorry, I was over there when I was kind of just trying to get a background from both sides. So I started with them because they had joined first, but I have them in a separate breakout room. I have you in a breakout room. And I guess the first thing I wanted to do is just ask you if you'd ever been through the mediation process before.
Yeah, I've done mediations before.
And in what context?
I'm sorry, I can't talk about that because I signed a non-disclosure agreement when I went through that.
Okay, but not a family case.
Sorry, not the what?
Not a case regarding your family.
No, never.
You've been in mediations regarding business.
Yes.
Okay. All right. I mean, their mediations really work the same in all processes. I just want you to know that I'm going to go back and forth between the rooms to see if I can broker an agreement between the two of you. The
Okay.
court requires you to do this process, and I'm just going to tell you, from a family court standpoint, the reason that they do that is because really, number one, they just have so many cases, they can't hear every single case. And through mediation, 80% of the cases settle in mediation. And so that helps them manage the number of cases they have to hear.
Okay.
I was the judge in the court that you're in back in 2013, 14, and 15. And then the state created another court, and the governor appointed me to take that one over. And then I was in that court for 5 years. So I was a judge for 8 years. And then before that, I was a family law attorney representing, husbands, wives, fathers, mothers, kids. And then since I've left the bench, all I do is mediate cases. I don't represent parties. I just help the court, help people try to get their cases settled. So what I'm here to do is try to see if I can get an agreement between the two of you. I'm not here to pick a side. I'm not here to do anything other than to see if I can get an agreement. It might mean pushing both sides beyond the position they want to, but that's how, as you know, that's how mediation works. It's a negotiation.
Yeah. I understand. If I may ask you a couple of questions because kind of important.
Yeah.
So could you tell me I'm sorry for asking, but what's your name?
David Perwin. You don't. Oh, I guess
Okay.
you can't see me reading.
Yeah, no, I can't see you. No. Okay, but okay, yeah. So I just wanted to make sure that I was talking to the person in the email. Okay, got it. Yes, I understand.
Yeah. So just so you know, anything that we talk about in this room, if there's anything that you do not want me to disclose to the other side, you let me know, and I will keep it in this room.
Okay, I understand.
The other thing is, if I do not report back to the judge about what we did today, all I will do is if we reach an agreement, I will send it to you to sign by DocuSign. I'll send it to her by DocuSign. Or if we don't get an agreement, I will just send a letter to in the court's file that just says that you mediated, but we did not reach an agreement. So the details of what we do are not disclosed to the judge directly. If we do have an agreement, it will spell out what that agreement is. So yes, the judge will know that. But anything we talk about in here, other than what's on the paper that's submitted to the court, is not disclosed to the court.
I understand, and I have other 2 questions very quickly. May I ask them?
Yeah, go ahead.
Yeah. So first question is: are you still part of the bar? Like, are you registered in the bar of Texas? I'm just curious whether you're practicing or you could practice law still, or you retired completely and did not register anymore.
Well, no, I'm still a licensed attorney, but I don't represent parties by choice.
Okay, no, I understand. And the other question I have, this field of mediation, is this a regulated profession? Like, is there a body that regulates your work, or is it like, everybody for
I
themselves?
mean, there are mediation organizations, but they don't It's not really regulated. Actually, what we do in our county is that you have to have 40 hours training of basic mediation, and
Okay,
then you have to have a 24-hour family law course that you also take.
I understand.
And
Yes.
that's the
Yeah.
minimum
So
requirement.
for training and certification. Yeah, but no, I just wanted to know if there were like, because like you see, like this is a very sensitive matter. Like there's a child custody issues. There's a lot of things, right? And you mentioned, that you may push one side or the other, beyond the
No,
comfort zone.
I'm gonna push both sides.
Both
I
sides,
push
right?
both sides, not
Right,
just
right, right.
one.
But no, no, no. I understand. I'm not implying anything, malicious or anything. But what I'm saying, right? Like
No,
it's a very sensitive issue, and I just wanted to understand if there are any regulations that regulate your role in this, right? Or if there are any laws that regulate, because like you understand, right? Like imagine that your child's well-being was at stake, and somebody else, a third party tells you, I may push both sides, outside of their comfort zone. You may be worried about, what that exactly means, right? And if there's any recourse in case things, don't. But I'm okay. I understand. So you're saying basically, it's an unregulated profession, and there's only an organization of mediators, but it's not. And the bar of Texas. So but no, I guess it doesn't have anything to do with this because anybody can be a mediator, right? No, even if you're not an attorney, you could be a mediator, right?
that's true. That is
Right.
true.
Okay.
But I'll tell you that what we're going to use, though, to apply anything that we're doing is the Texas Family Code.
Exactly. And because you're a judge, you were a judge, and you are a registered attorney, you're still bound by, the moral obligations of lawyers registered on the bar, right? And by all the laws that regulate that. But I mean, you're still a lawyer, right? So I mean, that gives me comfort that you're going to do the best that you can. Thank you so
Right.
much
Well,
for
I mean,
clarifying.
people come to me to mediate cases because of my judicial experience and because of my family law background. So,
Exactly.
because I was a
No,
judge for 8 years,
it's amazing.
and I cases like this, um, people come to me because of the experience that I have. But I also represented children before I was a judge in contested cases. I represented, like I said, fathers and mothers, and I did all of that before I was a judge. And since then, I used to mediate before I was a judge also, but
Okay.
coming off the bench and doing this, being a judge kind of lets people know that you have seen lots of cases. You have lots of scenarios that you have seen that help you try to come up with creative ideas and try to settle these cases.
Got it.
So, huge plus to being a judge. I'm not actively doing any. I do arbitrate cases sometimes where people come to me because they want me to make the decision and they don't want to go to the current judge.
Yeah.
That's by agreement. It's not any other way. And today, what we're going to do this morning is anything that's going to happen can only happen if you agree and she agrees. I cannot
course.
make you do anything.
Of
I
course.
can't make her do anything, but I can point out the consequences on what I think will happen in the court to give you a perspective and give her a perspective. But ultimately, it's a matter of you wanting to agree and her wanting to agree.
Perfect.
There is no, and if we don't get an agreement, then that basically is the box that needs to be checked so you can go forward with the judge and let the judge make the decision.
I understand. Thank you so much for explaining.
Yeah, and anytime you have any questions about any of this process, this is a good time to ask those questions because that's why I'm here.
Okay. Yeah. Well, not related to the process, but you said something that made me curious, and I'm just wondering. I don't know if you would like, if you don't want to share, don't share, right? But I'm just gonna ask. So you mentioned that a governor appointed you to a bench. I was wondering, was that Governor Abbott or a different governor?
No, it's Governor Abbott.
Governor Abbott. Okay, got it. Thank you so much.
Yeah, I didn't actually meet with him. I met with, I guess, some attorneys that work under him.
Mhm.
It was an interview process.
No, of
several
course.
people.
No, the governors are always super busy. I've tried to meet with a governor once, and he didn't come to the meetings. So
I mean, I had met him before, but
Oh.
in a group session, not in an individual
one-to-one.
session. But then after I was appointed, I was elected after that. So
Got it.
it wasn't just an appointment. I I was hired as an associate judge in the court that we're in with you. And then the governor appointed me for the new court. And then I got elected to serve a term after that. And then the next election, I lost the election. And that's when I just mediated cases.
You practice mediation. I understand. Well, thank you so much
Yeah.
for letting me, get a view into your career and your background and knowledge. That's definitely makes me comfortable.
Where are you? I think I saw something that I don't know, either they sent me or you sent me. So are you from Venezuela?
I'm originally from Venezuela. Yes, I was born there, but I left. Oh, your wife is from Venezuela?
No, not my wife, my law partner. She's
Okay.
from Venezuela. She was my associate judge when I was the judge in the 505th.
Okay.
And her husband is also from Venezuela. He's a veterinarian, and she's an attorney. And obviously, she used to be my associate judge. So,
Awesome.
it's,
That's good.
yeah.
Well,
So
great.
anyway, she's been here probably. I think she came here when she was, probably 8 or 9 years old, and her father worked for, like, I think an oil company, and they traveled all over the place and eventually came here. So,
Yeah, right. Yeah. Yeah,
But
everybody in Venezuela works for the whole company. Like
it
I
seems
did.
like it.
Yeah.
And it seems like most of the people interesting end up in Katy. She doesn't live in Katy, but a lot of her friends and a lot of people that I deal with from Venezuela are in Katy, and now they call it Katyzuela. I don't know if you've ever
Yeah,
heard of that,
exactly.
but
Yeah. Yeah. Half of Maracaibo, a specific city in Venezuela, is
yeah, that's where she's from. She's from there too.
Oh, me too. Yeah. And Gloria, the petitioner, is also from Venezuela,
Oh,
from
okay.
Maracaibo. Yeah.
Oh, wow. Okay. Yeah, that's exactly where my partner's from.
Yeah. So we might as well just go to court in Venezuela.
Well, I'm not from Venezuela, but
No.
you,
I'm just joking. It's
I
just a
know.
joke.
And a little bit of humor going through a difficult time is always a good thing.
It's
That's how
always
I
a
deal.
good thing. That's what keeps me going. Yeah, right.
Yeah, it's what keeps one too. I mean, I love doing family law. I probably would have made a lot more money going in a different area, but I do like helping people. So I'm hoping that I'll be able to help you guys.
To
maybe
be honest,
get
to be honest with you, I don't know how you do it. I mean, these family cases. I mean, if I don't know, I'm not a lawyer, but if I was a lawyer, right, I would think that this is probably the most difficult part of practice because, you would encounter people with all these conflicts every day. That you basically meet people in the worst moments of their life every day, right? I honestly I don't know how you did it.
But here's the thing: most people that are going through this are good people going through a bad time.
Yeah.
Different than me. If I was to do criminal cases
Right.
and I was dealing with really bad people, I don't want to. Even though I would be bound to if I was, if I took them as a client, I would need to represent them no matter how bad they are. I
Right.
do believe the concept, but it's not something that I choose to do. In
Yeah.
other words,
It's a
I
different type of
believe in
challenge.
right. And then the other areas of law just weren't of interest to me. I feel like I can, I guess, add something good to the world by helping people get through these type of things. So, and so that's kind of what motivates me, is to try to help people. And so, yeah, I want to get paid. I have 3 kids myself. I have 2 children at Texas A&M, and then I have one who's 14 years old. So I have 3 boys, and I mean, I need to support them, but I love helping families. And even if it's difficult, if I can help them get through this process, then that's something that is enriching to me as far as my life. So, I'm hoping to help you. Like, even if I can't, I'm hoping that you'll come away with some things that are, that you can take with you, that will be helpful in the future, whether it's the court or something beyond that. So I'm hoping that there's some positive things that can come out of this regardless, but I probably settle 90% of my cases.
Nice.
The average is 80, but I can't do that without the parties being willing to agree and attorneys that are willing to help the process, because this only happens with you saying yes and her saying yes. So with all that being said, I think they initiated the case. So what I'm going to do is I'm going to go back over to their room, and I'm going to get a proposal from them to present to you and for you and I to discuss.
Right, but I think, and I'm sorry, I know you have a plan, right? And I respect that, but I think given the circumstances of the case, and there are some things that are particular to the case, and before we go with the, before we go through all that process, if I may suggest something, it's just a suggestion, right? If you think it's not a good idea, we'll do it your way. But
go ahead.
so this is the let me see how I framed it. This is I'm gonna, in 2 minutes give you a short overview of the situation, right? Of this particular issue that I think it's gonna be a deal breaker. This is what I'm bringing this up at the beginning, right? Because without this item, I cannot agree to anything, right? And I know you as a mediation probably heard this every single time, but this is really important because it's rooted.
You know what? You're right.
Everybody comes into mediation like, like I'm not going to move 1 inch from here, but it's not about my position or ego or what I want. It's about a legal concept. Okay, the issue here is a legal issue, and that's great that you are, a former judge and a lawyer registered with the bar because you will have insight into this, right? So this is the issue for me. So the petitioner, she filed a petition for a restraining order against me with the court, okay? Signed by her lawyer. So the two of them filed that, right? This restraining order, the petition, the basis for it, they allege that I'm not in use of my mental capacities and abilities, and that I should be precluded from entering into any kind of legal contract of any kind. So they're asking the judge for a restraining order, so I cannot do anything. I cannot make any decisions, okay? And that I cannot enter into a legal contract with any party. Now, you see, the issue of capacity from a legal standpoint is critical here because the whole goal of this process of mediation is to get me to enter into a contract, into a legally binding contract with the petitioner. It's a fundamental contradiction. And I cannot enter into, they are saying that I cannot enter, that I should not be able to, or should not be allowed to enter into any kind of legal contract with anybody, right? So what I need to be able to proceed with this process is a handwritten note from the petitioner, the other party, saying that she does not have any reason to believe that I'm not in use of my mental capacity, right? Because otherwise it would be illegal for me to for them to get me into a legal contract, because they're saying that I'm not in use of my mental capacities, and then they're channeling me to enter into a contract with them, and that's illegal. It's taking advantage of a crazy person. That's typified in the law. And also, morally speaking, right? Like for you as a mediator, you have the moral duty to uphold the law. And you cannot, in good conscience, I think that's my contention. What I'm saying is my contention. Maybe I'm wrong, right? But I think in good conscience and morally, right, the principles that are upheld by the Bar of Texas, you cannot try to get a person whose mental capacities and abilities are being, let's say, questioned in a court to enter into a legal contract with the same people that are questioning the legal capacity of this party, right? So this is a fundamental issue for us to, even start negotiating anything, right? And that's why I said that without that I can't, because I can't, right? Like if they already filed that with the court, if they don't give me something in writing that says that they don't, both of them, right, don't have any reasons to believe I'm crazy, then the issue of mental capacity has to be addressed by a judge, right? It cannot be addressed by a mediator or by them or by me, right? It has to be addressed by a judge. So we will have to go back to the court anyways, right? So my proposal in that case would be, well, let's address the mental capacity problem issue first, and then let's come back to mediation. Is that reasonable?
Okay, it's right on point. I will tell you, if I don't feel, I'll tell you, there's a couple things going on here though. So let me kind of respond to what you're saying, and I don't disagree with the logic at all in what you're saying, but I want to I want to at least give you a response. From my viewpoint, just because they allege that you aren't mentally competent does not mean that you weren't mentally competent. So
No, but I might
no,
be. I mean, I'm
hold on.
thinking that I am, right?
Hold on.
And I need a
Stop.
judge to
Hold
tell
on.
me if I am or not.
Stop. Hold on. Let me give you my
Yeah,
whole
I'm sorry.
thing
Yeah, go ahead.
first, and then you can respond. But I want to say everything that I want to say because I don't want to lose my train of thought.
Got it.
So just because they allege that you are not competent doesn't mean that you are or aren't. That's an allegation that they're making. That does not mean that that's true or not true. Number two, as your mediator, if I feel that you aren't mentally competent to enter into an agreement, that it will be my duty to recess this until there's a determination made, and it would be my duty to not go forward if I have that impression. Now, I am not a psychologist or a psychiatrist, so I'm not doing a legal finding of competency, even when I'm using my own judgment to determine whether either party is of sound mind, because it's not just, a diagnosis on whether someone has some type of mental illness, but it could be if they're under some type of extreme duress or some other situational thing. If I feel like they're not capable of making a good decision, even if it's not mental illness, if I think they're of a mental state in this moment to not make a decision. And that doesn't mean if they're upset, because people are upset all the time. I want to make sure that they understand what they're agreeing to and understanding that what the consequences are. Not that I can give them legal advice, but they at least need to understand those kind of things. So anyway, but I understand what you're saying is that you can't have it both ways. They can't try to enter into an agreement with you and say that at the same time say you're not mentally competent. You can't have it both ways. Either they need to say that you're competent and they're entering this trying to negotiate in good faith, or if they're going to maintain the position that you're not competent, then a judge would need to make that determination, usually after a psychological evaluation. The judge is not going to make that just by hearing evidence. They would have to have something done in that regard. And then if the judge determined that you were not competent, then they would appoint an ad litem to represent you. But if they determined you were competent, then that determination will be clear.
Exactly. Yeah. Right on point. But just to, I agree with 99% of what you said. Only one small clarification, what I said, right, about your potential duties because you're a registered attorney with the bar. I didn't mean that I was expecting, just to clarify, I know you know this, right? Talking to you, I can tell that you're a very intelligent person, right? But I wasn't implying or saying that I want you to, or that I had an expectation that you would make a determination about sanity or insanity, not at all, or capacity. Because in fact, that's only a psychiatrist can do that, right? Like not even a judge can do that, as you said, right? The judge would rely on the opinion of experts. It could be a psychiatrist, it could be an FBI agent, right? Like it could be anything. Somebody who is qualified to judge.
It couldn't be anything. It couldn't be anything because an FBI agent doesn't necessarily have the qualifications for mental health. I mean,
but let me tell you why I say that specifically, right? The reason why they are alleging, that I'm crazy is because I reported a group of people to the FBI, right? That's the reason why they're saying that. So, to judge whether my claims to the FBI were true or false, the only people that can make that call is the FBI, right? Not even a psychiatrist. Like the FBI needs to look at what I said and say, yes, this person is right or this person is crazy, right? That's the whole contention. It's something, I'm not going to get into details what it is, but it's something around the FBI, okay? Now, so that's what I'm telling you that, like, yeah.
But even then, the FBI would just say, we find there's no merit. It doesn't mean that you're crazy because you might see.
No, exactly. But my position is that there is merit. I mean, I'm sure there's merit, right? So my expectation is that when the FBI says, yes, there is merit, it's obvious that I'm not crazy, right? I'm not expecting the FBI to say that I'm not crazy. I'm expecting the FBI to say, yes, these crimes occur. And if that's the case, then I'm not crazy. Like I wouldn't even have to go to the psychiatrist for the evaluation.
Okay,
Right?
but
That's the
here's the
path
thing.
I'm saying.
Yeah,
Yes.
now the FBI could have their own agenda, so they could say there's no merit just because they don't want it uncovered. So I don't
Oh,
think
that's
the
true.
FBI
That's
can
true.
make any determination on this. This would have to go to an independent mental health professional to make that determination if someone feels like that. The FBI, the police, nobody else has the authority to do that. And you making allegations of a crime, even if they said there was nothing to it or there was something to it, still wouldn't determine.
I mean, the sanity question, legalist. I
Right.
understand. Yeah, understood. Yeah, thank you for that. So, yeah, so I agree with you in pretty much everything. So the other thing I wanted to clarify is that the way you phrased it, you said something like you can't have it both ways, and I want to be clear, like it's not. I'm not using this as a leverage. Not at all. I'm just saying,
No, I'm
like
talking about them. I'm
yeah,
talking
yeah, no,
about
no,
they.
yeah, about them, yes, yes. What I'm saying is that because this question of capacity, mental capacity to enter into legal contracts, right, was already, you say it's an allegation, but this was a petition for a restraining order. This is filed with the court. This is illegal. This is an illegal document with the court because that allegation exists, right? My contention is that a person that is responsible for upholding the law cannot, has to take has to error on the caution side, right? Like, even trying to negotiate something with a person that has been alleged in a court document that should not be allowed to enter into a contract. My contention is that just trying to get them to just trying to negotiate could be a crime on itself. So that's all I'm saying, right? So the solution to this is simple. The petitioner can send me a handwritten note before we start negotiating anything. Like I'm not going to negotiate anything without this, right? Because I cannot. Maybe they're right. Maybe I'm crazy, right? And so I need to talk to a judge, to a person that can make this determination based on relying on the opinion of experts. So I have to question myself if they're right. Just negotiating with them could put me in danger. Like could put my welfare, my financial welfare in jeopardy because I cannot trust my own capacity, right? Because of what they're saying. So the first point that we have to get out of the table is that handwritten note from the petitioner saying that she has absolutely no reason to believe that I'm not in full use of my mental capacity and abilities. If we can get that, I'm open to negotiate anything, open to anything. But if we cannot get that, I think we should cut it short because all our times are valuable, right?
Okay, let me ask you this though. Just because she says it doesn't mean that it's true or not true. I mean, she may have her own motivation to saying that you're competent so she can take advantage of a disability.
I understand, but because I trust her so much, because remember, I was with her for a long time. Maybe she's right. I have to consider the possibility that she might be right. And if that is the case, I need a judge, and I need that a judge makes that determination. Like I can't take my chances on that, right? Because she might be right. She might be right. I might be a little bit crazy. And I can't gamble with the welfare of my son, So that's why.
No, I get what you're saying, but it sounds to me that you're saying that you will accept her determination on whether you are competent or not to go forward.
No, not at all. She's not a licensed psychiatrist and not an FBI agent. So
I know, but you understand what you just asked me to do, though. If I go over there and say, we need you to handwrite a note saying that you believe that he is competent, that you're willing to go forward with that letter.
I'm willing to move forward to the negotiation. Yes.
Right.
Yeah. Yes. But that doesn't mean that I'm accepting what she wrote. Even if she wrote that, I may
why would you go forward?
Well, I won't go forward because delegation is that I'm not competent, and honestly, to protect you. If I go forward, imagine this situation. If I go forward and negotiate with them, I can imagine, right? I could then tomorrow file a complaint with the bar saying that you channeled me to enter into a contract agreement with a group of people that allege in a court document that I'm crazy. I'm not a lawyer, and it's not my place to give legal opinions, but I think that a lawyer could be disbarred for that. So I'm protecting you in reality. I'm protecting them because I could also go and then make a claim that they took advantage of a crazy person. So for all of us to be safe, right, the best path forward is that there is something in writing that says that the petitioner has no reason to believe that I'm not in use of my mental capacities. It's just an opinion. She's just expressing an opinion. It's not a judgment. It's not an assessment. I'm not going to use that as anything. It's just her opinion, right? But I want to have it in writing because that way we're all protected. Like there's no crimes being committed. Like nobody's violating the moral, rules of the profession, and we're all happy, right? And we can move forward and we can negotiate this. And I'm telling you, I'm very open to negotiate, and I'm willing to be flexible. I want to solve this today, but I can't enter into any kind of negotiation until she gives me something in writing that says that she's trusting that and this is not an unreasonable request. I mean, we're negotiating here a legal contract. I mean, this is just basic, right? This is a very basic concept of law. So I don't think I'm asking for a kidney here. It's just a very simple request. It costs them nothing really to write this handnote.
Okay. All right. So here's my response to that. I have no problem doing what you're asking me to do. I guess what I'm going to say though is, and I haven't, through our conversation, I don't have any indication that you're not of the capacity to make a negotiation. I'm not saying that I'm asking you to rely on me saying that. I understand that they have made statements about you, and they can't have it both ways in the sense they can't say that and then negotiate with you if they think that you're mentally not competent. That would make the agreement, if we reached one,
invalid, right? I could just go back on the agreement tomorrow. Like it doesn't.
Right. That's right. I mean, the court would have to find that determination that you weren't competent.
Right, but I could fight it. So, and it puts into question the purpose of all this negotiation, because we're going to negotiate, spend 4 hours here, enter into a contract, and then I could go on Monday to the court and file for a petition to annul that, to nullify that contract, right? Like I would be within my right to do that. So it's a waste of time for everybody, right? So I think that
I agree.
Yeah.
Hold on, let me ask you a quick question. What do I call you?
My name is Rinaldo Aguiar.
Okay. So
you can call me Rinaldo.
Okay. All right. Rinaldo. Okay.
Mm-hmm.
I just wanted to get that out of the way because we haven't really talked about that. And so,
yeah.
Okay. Well, look, I understand exactly where you're coming from, and it's a very strong position that I agree with you. I mean, they can't say they want to negotiate with you, and I can't find. I was trying to see that restraining order that you're talking about, and I don't have a copy of it.
I can email you a link to it.
Okay. If you could do that, that would be helpful, because, I mean, but you understand that what they're doing is they're alleging these things, but they can't have it both ways. They can't say that they believe that you have this mental deficiency and then ask you to sign something agreeing to commit to financial obligations, a parenting plan regarding your son.
No, well, and not even ask me to come to mediation. I mean, I think that on itself, right? It's questionable. Like, how can you say that somebody's crazy and then the judge says, "Well, go to mediation." Yeah, sure, let's mediate. I mean, the lawyer, who is a lawyer registered in the bar, I believe her moral duty was to object to what the judge was saying in that very moment and say, "No, judge, we can't go to mediation because this person is crazy, and we cannot enter."
But remember this, the attorney does not have any personal knowledge of you at all. She is only a mouthpiece for your wife or your.
No, I
Or,
understand, but if she has to assume that the allegations are true, right? Because she filed that document with the court, and just by having that assumption, any person that, if you really believe, right? If somebody tells you this person is crazy, this person next to you is crazy, and then the same person tells you, let's go negotiate with that person. The logical answer is, you just say that the person is crazy, right? The lawyer should have at least questioned the client, or but I think agreeing, she agreed in less than a second, right? And this should be recorded in the court hearing. She agreed immediately. Like, she didn't even, looked up to think about it. Like, no, immediately she said, yes, sure. And she started making the appointments. And, to me, that seems odd, right? But anyhow, I'm not gonna, question the lawyer. Just
well, let me just say this too. And this does not change at all what you want to do and what I'm going to follow through and address that for you. But there are times when there are people, and this is not you I'm talking about. I'm just telling you that I've been down this road before. This
Okay.
And
In new
for me.
right?
Right. There are times where someone who may have mental issues have periods of time of clarity. They're not always mentally off. So, there are those times where someone can have mental issues, but still be like, if someone wanted to do a will, for example, they may have moments of clarity where they say, hey, I want X person to get this property, this property, this property. And then let's say the next day, they can't remember who they are or who they are. So there is times where it can be where someone is mentally off at one time and perfectly clear the next. But that's where it gets really great.
Yeah, it's kind of tricky, right? Yeah. No, I totally understand. It's a tricky, and that's
There
why
are
a
times
judge,
like,
yeah. So I'm sending you right now the document.
okay. I want to take a look at it and let's discuss it before I go over there. So
Yeah, that sounds like a good idea, because it's a sensitive issue, right?
yeah.
So I'm gonna tell you verbally. It's paragraph 3, 3B, and 3F on the document I'm going to send you. I'm gonna note this in the email anyway.
So this says, some notes that I have says that both of y'all have, she has a Model S, and then you have a truck, and we're not going into the negotiations. I was just asking out of curiosity, what kind of Tesla do you have?
Model S.
Well,
So
both of you have S.
yes.
Okay.
Yes.
I just got a Tesla in August. That's why I was asking you.
Oh, yeah, it's a nice car, right?
Yeah, well, I've got the Cybertruck, and I
okay.
am, and I love the truck. I love, the speed and the ease of steering and the uniqueness of it. My wife didn't want to get in it. She said it was so ugly. But
Yeah, it's a divisive subject, right? Like, some people love it, some people, exactly, some people hate it.
The one she wrote in it, she really liked it, so that was good.
Okay, let me ask you a question.
Okay.
What is your email address? Because I have Becky's, but I don't have yours.
Yeah, so just switch Becky's name out for David. So David@perwinaguirre.com.
Okay, David.
And I did see an email from you, but I
Yeah,
don't know.
but because I don't have access to that email address, and it's a different account, and I don't have it in this computer, and that's why. So I'm gonna mail you from a different email address, which is my personal email address. Okay.
Okay, so the one that Aguiar at Reynaldo.ca, I just sent you an email too. So if you can't find mine, you can respond back to that one if you have access to that.
Let me see. No, I didn't receive that one here. But okay, but I'll send it. I'll send this. I have the email already drafted. I'm sending this to you right now.
Okay. Okay.
Yeah, no worries. Okay, so we said 3B and 3F.
Now, if and this is kind of getting way ahead of the thing, but if we resolve the mental capacity issue, and if we were to reach an agreement, is the email that I sent to you not the correct email to send?
I mean, yes, I have access to that email, but how do I say
Oh,
this?
you
Like,
did send me an email.
yeah, I sent you. Yeah, the thing is that I have two email addresses, and one of them is in a different computer that is in my office, and I don't use that for security reasons. I don't use that email address outside of the office.
Well,
And
you
the one
sent
that
it
I'm
to me
going,
at 2 in the morning. Did you
yes,
sleep today?
yeah, a little bit. I slept like 4 hours. But I was at the office when I sent you that. That's why I sent it from there. But now I'm home, so I'm gonna use the email that I use from home. But either one, like
Yeah.
if it's something time sensitive, I'm just saying this in case this extends beyond today or whatever, and you need to reach me. If it's time sensitive, use the one that I'm going to use right now because I have that on my cell phone, right? I can access that anytime. But the other one, that's the reason why I made the payment last night or early this morning, because that I hadn't gone to the office in a few days and I didn't see your email about the payment. I saw it last night when I was there. That's why I made the payment late, basically 2 hours late. But anyhow, I have the email here. I'll send it to you, and then I guess you're gonna go to that room, and I'll see you when you get back, right?
Yeah, but I want to look at the restraining order and talk to you about it first, or at least discuss. I want to see it first before I go over there.
Okay.
So if you could
Sure.
send that to me, and I'll see if the court, our district clerk is not doing the greatest job of making. I know for some people they're glad that no one can see any files in there, but for attorneys who want to try to understand what case they're working on, we can't
Yeah.
access or
No, and this one, oh, I got your email. I got your email because I forwarded. Yeah. Yes, you're right. And this, you wouldn't even, regardless of the clerk, you wouldn't be able to see it because they marked it as, containing sensitive information because
Right.
it's
Anything that has a child's name is considered sensitive. So
yeah, but they could have redacted it, redacted the name of the child with the
well,
auto redact
yeah,
tool, and then
but you
make
can't
it
really.
public.
If you file it redacted, then it really isn't a complete document. Okay, so
Uh,
I'm looking at the restraining order now. In what section did you want to direct me to?
so, well, this is very clear. I think 3F is the second page. I think it is. It says order Reynaldo Aguiar. It says ordering the psychiatric evaluation of Reynaldo Aguiar Marcano. That's
Yeah, so if you look at three itself, it says petitioner requests the court after notice of the hearing to do the following. So they're asking.
right. But on the numeral F on the page 3. So
Yeah,
yes, they're asking for a number of
they're
things,
asking
right?
the court to order it.
Right. No, I understand. No, the restraining, or like the judge hasn't ordered a psychiatric evaluation yet, but they asked for it, and for me, that's enough.
That's right.
Right.
That's right.
hmm
Yeah. So if you don't have the mental capacity to do something with your child, how do you have the mental capacity to dispose of your property?
No, or even to negotiate, right? I mean, not
Right.
even.
Right.
I mean,
Yeah. I was just. I guess I said it. You said it better than I did as far as on anything. It's not just the child. I just separated. You have children issues and property issues, so that's why I said it that way. So you can't say that you have the mental capacity to negotiate property if you're saying that he doesn't have the mental capacity to even have a parenting plan regarding his child.
right. Exactly.
You can't have it both ways. Okay. All right. So what I'm going to do is I'm going to go over there and address that with them. And I'm just going to tell you my thought on this is that I think there should be an evaluation done before we do anything.
And I agree.
So
Yeah.
if they say everything is fine, then we can go forward and then they can drop their claim. And if not, then the court would have to make a decision on what they're going to do.
No, I agree with you, right, in principle. But the other, I mean, the trade-off for me is the welfare of the child, right? If if they're willing to give me that piece of paper and we can negotiate and resolve this today, and I'm able to see my child, that's a win for me, right? That's all I need. I don't. That would allow me to not drag this for a year, right? But if that's impossible, if they cannot, meet this basic simple requirement, then, I'll have to.
She is not concerned that you're going to harm your child. She's already told me that.
No. I understand. Like I would like to like make the
But you
separation.
need a written declaration, correct?
Right, and as I said, right, I could go back on Monday on the contract. I could go on Monday to the court and apply to have it nullified. Right, like it's a waste of time for everybody. Right. So for
I
this
understand.
contract to be sound and binding and legally, correct, we need this requirement because they already made that allegation with the court. I mean, this is on them, right? Like
I
they
agree
made
with
that
you.
allegation.
Yeah,
Thank you.
that's a good point. All right. I'm going to go over there and address that with them. So hang in there. It might take a little while to negotiate that.
I understand.
Okay. Ronaldo, are you there?
Yes, I'm here.
All right. Sorry for the delay. We had a lot to talk about, and I want to kind of tell you kind of where I think things are going to land as far as this. So she does have concerns about the mental capacity, and obviously it's not. I'm taking it from a caring standpoint, not from one of some type of negative, label on you.
Oh no,
At least
don't worry. Like no need to. Like I don't take these things personally. So I understand what you're saying. So, well, please finish. I don't want to put any words in you.
And so to me, I think if there's an assessment being made, if you're willing to agree to that, or even if you aren't, I really think that the court would need to appoint somebody to have you go to do that assessment. And I don't think until the results of that assessment come out, we can do anything. I don't even feel comfortable asking you to agree to assessment because that is a conflict directly with what we're talking about.
Exactly.
Right?
No, I congratulate you. Like you're really taking the how do I say this? You're taking the you're upholding the law. You're doing what you're supposed to do. And then I agree completely with you. This is something that should be reviewed by a judge, and
Yeah.
and he should decide what is the best course of action, right? Like until that happens, wasting time and energy and
Right.
causing
Right. And so this
friction
is
between
what I
people.
told them we would do
Mhm.
is that I'm going to pass the mediation. And then what I told them is that once the assessment is done, then, we were scheduled for 4 hours. So what I told them that I would do is the 2 hours that we didn't use, I would apply them if everything comes back fine, or even if they don't, the court will probably at some point return you to mediation. I will apply those 2 hours
Wonderful.
to a future mediation. I'm not
Okay.
going to just say, oh, I used up, because even though I blocked my morning, I can't make money doing it. I'm not taking that position.
I
What I'm
appreciate.
saying is I'll
I appreciate that.
and apply it to a future.
To a future mediation,
Yeah.
if that's the case, I understand that. And if that's not the case, then please keep the 2
Yeah, but-
hours. Like
Well, I want to earn my money. So that's
Yeah.
kind of what is that you will, at some point, you will have to come back to mediation. I know that 100%, unless you all reach an agreement without it. So if y'all reach an agreement without it, then of course you wouldn't have to, and that would probably be a plus for everybody. But
yeah.
but
No,
if you had to come to mediation, I'm going to have my office manager, Becky, make a note that you have a 2-hour credit
okay.
to a future mediation. And then I'm going to let you know that her attorney is going to set a motion to ask the court to appoint someone, and then you'll have the opportunity to be present. And if you want to object to it, or if you want to agree to it, or whatever it is you want to, you'll be noticed and have the right to, respond to that.
Okay.
But we an agreement. I can't do anything, so that has to happen on the judge's own action. It can't be by agreement.
Yeah. Well, if I may ask you one favor, could you update? Well, I can ask your office manager to update my address because I'm in a different address now than the one that you probably have. So I'll do that. I'll update my address with the court and with your office manager and all that. Okay.
They don't notice you. Normally they notice you by email. You don't get notices by email.
Oh no, but because you said that I'm gonna be that she's going to file a petition, right? That means that I'm going to be
not a
serviced.
petition. It's going to be a motion. It'll be a motion for, a psychological evaluation.
Right, right.
And so
But
they
there's
don't,
gonna be
they don't
a
serve
legal
you.
service, right? There's gonna be a legal service, and
No, hold on.
no?
That's what I'm trying to explain to you. The service on that will be by the email, whatever email
Okay, got it.
that you
E-filing. Okay.
get. You're not served in person on this motion. You're sent an email. If you're e-served, whatever email address is connected to you in the case is how you'll be noted.
Right, right. No, I understand that concept. The thing is that the last
Okay, I thought you were
when they
about the process server
No.
coming to you.
yes
your
because
house. You can
yes
separate.
because when they filed the petition, right? Although they could have served me electronically, they choose to send a process server, and the man transpassed, and there was a whole incident. He was provoking me in my own home, and I want to prevent that from
Yeah.
happening again. So that's why I was
Right.
concerned about the address, right?
Right. Yeah. Hold on one second though. The petition for divorce. Is that what you're talking about?
The petition for divorce and the motion for the restraining order and the injunctive orders, and like there was a series
Okay.
of legal instruments they filed, and the petitioner had my email address. Like she has had it for 11 years, but they choose to send this man in person to trespass the property lines and ignore the not trespassing sign and all those things in person, right? So that's why
Let
I'm
me just say
concerned.
that-
I don't want that to happen
No,
again.
hold on one second.
Mhm.
The petition had to be served in person. They cannot e-serve you the initial petition and notice of a restraining order that was signed by the court. Those have to be done in person.
Okay, I understand.
So once you've been served in person with the initial pleading, mostly everything else can be done by
Electronic.
but not the initial one. So just so you know, I don't think that there isn't, and I haven't discussed this with them. I'm just telling you the basic law for what we're dealing with.
Got it.
Is that you have to be served with that because that confirms that you were actually given notice of the lawsuit.
No,
And
no,
then
I
once you
understand.
filed a
completely.
response, then they can e-serve you mostly everything else. There are a few exceptions, but I'm not going to waste your time
Okay,
with the exceptions.
but now that
After
you're gonna,
you'll be-
so sorry if I may ask you for a favor. Now that you're gonna communicate to them in some capacity in the future, if you can, please ask them to not send anybody in person to my home. Is that feasible?
I will do that.
Okay, thank you.
Now, just so you know, certain things like, let's say there's a restraining order. Some things they can't do it by e-service because there's
Because
no
of the
evidence
gravity, right? No, I understand that.
They
Yeah,
have to know that you received it. But I will tell them. And do they have the email? Has she communicated with you already through?
oh yeah, no, she texted me this morning. Like she has my cell phone, my email address. You know, like I saw
I'm
her.
not talking about text. I'm talking about email.
Yeah, she has all my electronic communication channels.
Who is she?
Both the attorney, Hyper,
Right.
and
I'm not talking about your I don't even know if I want to call her your ex, Gloria. All I care, as long as the attorney has a good email for you, that's all I want to make sure of.
Yeah,
So
she
I will
does.
let them know to communicate with you through that email that she already has for you.
Perfect. Yes, that's agreeable.
All right, that's what I'm going to do. You're 100% right. We should not go forward. It doesn't make any logical or legal sense to do so at this time. And then they're going to, I guess, ask the court will have to figure out who would be the proper person to do the assessment. And then, just so you know, I know that Gloria, at least in what I've read, is somewhat concerned about her financial situation. Just understand that, that may be something that she may deal with you directly to try to, it sounds like she's had some money, but she doesn't know when she'll have money or not have money. And while the case is pending, she may reach out to you to try to get some financial support while this is pending. But that's, as I told her, that's between you guys on how y'all work that out.
Of
That's
course,
not
of course.
for me to do at this point.
I understand. Yeah, and thank you so much for the heads up.
All right, I'm going to go ahead and impasse it, and I hope I'd love to talk to you again in the future, and I hope that unfortunately you'll be under these circumstances, but I want to be able to help you guys I feel like I pushed y'all the right direction, but I don't feel like I've completed what I want to do to try to help y'all. So hopefully I'll have that opportunity in the future.
Thank you so much, sir. I really appreciate your time, and again, I congratulate you for, for making the right call. Thank you so much.
Thank you. I appreciate that. Have a great afternoon and good weekend for you.
You too. Thank you so much. Bye bye.
Here.